Good morning, everyone. Welcome to this talk on directors' duties. As hopefully you've seen from the advertisement, today's talk is on directors' duties. It being a King's Young Professionals event, the context and the substance of the talk will be largely on the fundamentals. There will hopefully be some nuggets and nuances for those of you who are slightly more experienced. But in any event, hopefully there'll be something for everyone. There's two things I should get out of the way first. The first is that if you have questions, do please drop them into the chat. And secondly, I should say that I've largely managed to slough off most of my American accent that I was born with. Apparently, I've been told when I'm doing a talk on exactly this subject that it's the word duty where I sound more American, more profoundly American than at any other point. So let's get that awkwardness out of the way if I start to slip back into my New Jersey drawl. So what I've done with this talk is to characterize it as 8 things that everybody really ought to know in relation to directors' duties. We'll start with looking at what the duties are, how we find them, how we identify them, and then we'll look to see what sort of remedies there can be when directors' duties are breached. If you were attending a talk on directors' duties, or indeed you saw an advertisement to that effect, you would no doubt be expecting some sort of talk and some sort of discussion about the core duties. These core duties are found at sections 171 to 177 of the Companies Act, as I'm sure most of you know. In terms of taking a step back in relation to these duties, one of the things that I think is interesting and important is that these duties essentially mimic and mirror fiduciary duties that are owed by trustees to their beneficiaries. And that is an importing function that fiduciary duties take on when they're not in the context of a trust. They mimic and begin to look like what trust duties look like. So in essence, they have 2 main functions. They're to drive the single-minded fidelity of the director to the company on the one hand, and on the other hand, to ensure that there is no conflict with that duty, whether from a conflict of interest, benefit from a third party, and declaring arrangements. Declaring an interest in transactions and arrangements. But this creates a paradox, and it's a paradox not entirely unique to directors and to companies. The paradox is, where there are cases where directors are serving as directors of the company, they have no necessary consideration or entitlement to any remuneration in respect of their conduct at that office, and very much similar to that of a trustee with a beneficiary. Now, we can't feel too sorry for directors because generally they will have arranged things such that they have a corresponding salary agreement or they have some sort of shareholding interest within the company. But at the same time, it's interesting to note that this highest class of duties, this fiduciary duty, which involves single-minded fidelity, is affixed to those who need not get any consideration immediately for it, whereas an employee does not have quite the same level of duties to the company. He can, as it were, play the job's worth and simply do what's in his contract. He doesn't have quite the same proactive duties as does the director. So those are the core duties, and you presumably expected me to talk about those. But it's as well to know that there's no analysis of directors' duties that would be incomplete without considering what's in the other 1,000 or so sections of the Companies Act 2006 that weren't on the previous slide. If you go to the CPS website and look to what they say about criminal offences under the Companies Act, there are no fewer than 86 provisions which contain a criminal penalty. Now, most of those duties, which are actually dischargeable by the company in the first instance. So, for example, the duty to keep records pursuant to Section 386 is a duty that is owed by the company. But if the company is in default, the criminal liability falls upon the officers of the company and the company as well. And that's true of various provisions within the Companies Act, including the duty to keep a register of shareholders and a register of members. Most small companies are probably in breach of that as we speak, and their directors are incurring criminal liability as a result. So there's a huge, vast array of duties that are owed primarily by companies in the first instance, but are owed by the directors to discharge those duties as well. And as I say, the consequences can, at least in theory, be serious. I've just chosen one example to highlight for this purpose, which is a duty to keep accounting records. There's a Section 386 provision, which demands that companies keep records, and 387 backs that up with criminal liability. Now, why have I chosen this? Because in addition to the question of potential criminal liability, which, let's be honest, is probably going to be very unlikely in most cases, there is also the potential for the use of this duty being used by liquidators, office holders, or a company itself to go after directors who are in default. So very frequently, especially when you're dealing with small companies, if you're acting for a liquidator or an office holder, one of the defenses that persons will attempt to raise is they'll attempt to raise a defense saying, well, I'm sorry that the books look like this, the records look like that. I'm really sorry, but that's as far as it goes. I did things very informally. I was a one-man band. I'm not trained as an accountant. It's because they have that pre-existing duty that the court will be very reluctant to allow them to simply point to their own failings and shortcomings in the conduct of their office and their functions in order to get out of liability altogether. While we're on the subject, in addition to the other duties under the Companies Act, there are other duties that are owed by directors that are not owed by them qua directors, to use the Latin. The directors may also have additional duties, either in their capacity as shareholders through shareholders' agreements. They may have service agreements or employment contracts. Those aren't pursuant to their duties as director per se, but they're often worth bearing in mind. I once had a case that involved a lot of complicated technical analysis between both sides as to whether or not a certain person was a de facto director of the company. He claimed he wasn't, we said he was. But by the time it got to trial, I said to the judge, ultimately, I don't care, because I've got this employment contract, and everything that we want to criticise him for would be a breach of his employment contract in any event, whether or not he's a director. So it's as well to bear in mind that directors will have those duties as well. We have these directors' duties. We've got the core duties within the Companies Act. We've got other duties within the Companies Act. And then we have potentially ancillary duties that directors owe by dint of other offices. I want to zoom in on one in particular, Section 172, that we looked at as one of the core duties, in terms of what the directors must have regard to when promoting success of the company. A certain silk in our chambers referred to this as one of the most new Labour pieces of legislation he'd ever seen, in that it takes a very sort of airy-fairy approach to saying you have to have regard to the whole community and vast swathes of different stakeholders. But the paradox is that even though you're meant to take into account the employees, suppliers, customers, etc., you do that owing the duty to the company. Save in very rare circumstances, those persons whose interest you must take into account, you take into account as a function of doing right by the company. You don't normally give them special rights as against you. And that brings me on to the fourth principle, which is that directors don't usually owe fiduciaries duties to individual shareholders, those fiduciary duties being the core duties we've already discussed. As I said earlier, and as the previous slide suggested, the core duties are owed to the company, not to the individual shareholders. That's what Mr. Justice Nugent, as he then was, tells us in sharp and blank. So what do you do if you are an aggrieved shareholder? You do have means and remedies. You can remove the directors by ordinary means, by a resolution, by a company meeting. You can take a derivative action. You can lodge an unfair prejudice petition. Derivative actions and unfair prejudice petitions, of course, tend to be very expensive remedies. But what's important to recognise is that those remedies, the derivative action, the unfair prejudice petition, they aren't actually meant to impeach the general rule that the individual shareholder as a member is not owed a particular duty by the company director. They're simply remedies to prevent the grossest forms of abuses by those directors, and indeed by the companies that they control. They're not licensed for saying that there is a freestanding obligation for every director to look at every shareholder and say, I owe this duty to him, which he can then enforce as against me. So, now that I've set out that general charter about duties that are owed by directors to shareholders in special circumstances, I now have to qualify that by saying that Mr. Justice Nuji, in the next paragraph in sharp and blank, allows that there can and will be some instances where there will be cases where directors owe special duties to shareholders. And I have to say, as a matter of generality, you always hate it when the court says, here is a general principle. In order to impeach this general principle, you will need something more or something additional, without necessarily telling us what that is. And so we're told that, of course, there's no general duty owed by an individual director to an individual shareholder, save in special circumstances. Now, the key I think, to understanding what those special circumstances are is to look at one of the cases that Sharp and Blank cited, which is the case of Peskin and Anderson, and the judgment given there by Lord Justice Mummery. And I think that what he deals with there, the instances that he's talking about that breach this general rule and create a specific exception, I think are very telling, where he talks about individual directors making individual approaches to shareholders in relation, for example, to a specific transaction. And I think what's really telling here is that what he says is, in part of the bit that I've highlighted, this can include cases where they're holding themselves out for them in connection with the acquisition or disposal of shares, or making material representations to them. So just pausing there for a minute. What's happening in these special circumstances where directors are outside the general rule and are actually owing individual duties to specific shareholders? Well, it seems to me that Lord Justice Mummery is telling us about as explicitly as one can that it's in cases where they're taking on an additional fiduciary relationship, for example, that of an agent. So it's not because one person in that situation has a director's hat on and the person they're dealing with has a shareholder's hat on. It seems to me that the analysis is that it's instances that create special circumstances are where the directors and shareholders are not behaving as directors and shareholders normally would. They're stepping outside that and creating a special sort of relationship between them. I have to say, as a matter of practice, 10 years or so in the saddle, I've never seen such an instance come up in my case law where I can say, aha, there is a special relationship, or a special relationship has been proposed by the other side. So it's a very rare set of events, but it's worth bearing in mind. And as I say at the bottom of this slide, I think the analysis here is backward-looking. We tend to think of fiduciary relationships as being analysed forward. So we will say, so-and-so is a de jure director of this company, therefore he owes fiduciary duties. But in reality, many of the fiduciary relationships that are created throughout the law work the other way round. It's because you take on fiduciary-style relationships of trust and confidence and single-minded loyalty, that we look backward and say, therefore you are a fiduciary. So you look at the character of the relationship that's formed, not necessarily the titles that are attached to it. Sixthly, and perhaps one of the more substantive of the 8 points I wish to raise today, is the directors sometimes owe duties to creditors. Now, remember section 172, which I specifically highlighted earlier, which set out the duty to promote the success of the company, and then listed various classes of persons who must be recognised and who must be taken into account when our director moves to promote the success of their company. Well, 172 contains an even further complicating qualification, which is to say that the duty imposed by this section has effect subject to an enactment or rule in which directors must, in certain circumstances, consider or act in the interests of creditors of the company. So you have a legislative regime which doesn't make a lot of sense. It says your duty is to the company. You discharge it by looking at all of these classes of persons. Oh, and by the way, that has nothing to do. That has to sit alongside somehow this duty that you owe to creditors. How do you reconcile it? Well, that was the first of the three questions that the Supreme Court had to wrangle with in BTI and Sequana. The first of the three questions it had to ask itself is, what is the nature of this duty that is owed to creditors in an insolvency situation? And the Supreme Court eventually decided that the best analysis was that it wasn't a freestanding duty owed to creditors, which could jump in and trump the other duties. Rather, much like the bulk of Section 1721, where it lists the classes of persons, what happens in an insolvency situation is that the fiduciary relationships you owe to the company are now characterized as taking into account the interests of creditors. So just as in a non-insolvency situation, you owe the duty to the company, and you express that duty by thinking about lots of people and taking their interests into account, in an insolvency situation, the creditors get a seat at the table. The second and the far more complicated question that the Supreme Court had to grapple with in Sequana was the extent of that duty. At what point does it bite? Or as the Supreme Court put it, at what point is it triggered? And even though their lordships gave a series of different and slightly differently nuanced judgments, the core holding in Sequana appears to be this. You don't owe a duty to creditors if there is a mere future hypothetical risk of insolvency. The creditor duty comes into play where the company is insolvent, borderline insolvent, where an insolvency event, liquidation or administration is probable, or if there's a proposed transaction that would lead to insolvency. And it seems as though that the best analysis of the case is further to say that the creditors get a seat at the table when the provision is triggered, but the extent to which you have to have regard to their interests is factually sensitive on a sliding scale. As the risk of insolvency goes up, the interests of creditors go up and up and up. There are earlier cases which say that in a situation in which the company is insolvent, creditors' rights are paramount. That sort of language, I think, is to be less preferred now that we have this sort of sliding scale analysis. If the company is hopelessly insolvent and headed straight for liquidation, then yes, the members' interests will fade into oblivion fairly quickly, and the creditors' interests will be the trump card. But there's far more shades of grey in the twilight in which companies begin to approach an insolvency situation. Sequana was more recently considered in the case of Hunt and Singh. This was a case in which Mr. Justice Zaccaroli was dealing with a question on appeal. And I should say one of the reasons that this judgment was perhaps limited in how far it was likely to go is that Mr. Singh, in the interim, was made bankrupt by his own petition. So Mr. Justice Zaccaroli was not addressed by counsel on two sides, but only one. Mr. Justice Zaccaroli faced an interesting question. In the Sequana case, the question was whether or not directors should have declared a dividend at a point at which the company was not insolvent, on the basis that there was a risk that the company would become insolvent. But at the time of the dividend, there is no doubt that the company wasn't at that point insolvent. That was the Sequana case. And the Supreme Court had to look at an instance where the question was about the director's judgment and the extent to which they should have taken creditors' interests into account. The case of Hunt and Singh was a bit different, because that concerned an all-or-nothing case of insolvency. The company in question had a massive HMRC claim made against it. If that claim held, the company was insolvent. If that claim didn't hold, the company was solvent. So at what point, if any, are the interests of creditors to be taken into account? As it was in a fact-sensitive case, Mr. Justice Zaccaroli said that at the point of HMRC's claim, that was sufficient to trigger the creditor duty. And he then went to look at the question of the creditor, the knowledge of the directors. And I think what he's done here is to move us as far as he can towards a more objective test. It's unclear at this point even now as to the extent to which knowledge will be required, and what sort of knowledge will be required to trigger the duty upon directors to consider the interests of creditors. But it seems to be that the best analysis we get from that judgment is that if you face, even in this case, a claim which is of such size that solvency is dependent on successfully challenging it, the creditor's duty arises if you knew or ought to know that there is at least a real prospect of the challenge failing. So again, this case didn't go very far, and it may be limited in its scope and application, but it's an interesting move towards an objective analysis of where we look at where we look following Sequana, and it's an objective analysis as to where the company is now, not simply looking forward as to where its solvency might be. The question of delegation of directors' duties is one that comes up quite frequently, and in my experience, this usually takes one of two forms. The first is that you have a very small company which is controlled by a small number of directors, and the directors have divided up the duties between them. So someone is on the shop floor doing the day-to-day, someone else is back office. And sure enough, something goes badly wrong, usually in the back office, and each director stands back and says, that wasn't me, that was them. The other instance in which that can happen is where directors bring on professionals or others, especially accountants, to manage things, and then say, don't look at me, it was the professional, and I delegated this duty to someone else. To what extent is that permissible? The answer seems to be, I think that the language of delegation is probably misconceived. Delegation to me suggests that you give it to someone else and you forget about it. And that's not permissible. I think that the better analysis is to say that you can discharge legitimately your duty pursuant to the Companies Act by bringing in expert advice, taking counsel, or indeed dividing up tasks between you and your fellow directors. But what you can't do is you can't simply leave the field to them. You can't simply take no interest in what they're doing, such that the company goes to shambles. You have to exercise some level of supervision. And as I say, and as indeed ICC Judge Briggs says in the Glamon Town Limited case, it's a fact-sensitive matter. But I think a very good maxim that I've heard before is delegation is permissible, abdication is not. You have to stay interested in the discharge of your functions, but there is an extent to which the day-to-day can be done by others. And finally, the eighth principle, which I come across quite frequently in the insolvency work in which I do, is that the burden of proof, you can look at it this way at least, the burden of proof shifts when a director finds themselves in possession of company property. And it's interesting as well, specifically, that in the case of Maru, it was taken into account what we discussed earlier, the fact that directors owe duties to maintain books and records. So if you've got books and records where it shows that you've received company property, the company or the liquidator who's trying to get that property back from you is entitled in the first instance to rely upon those books and records. And it's no good for you to say, well, don't look at me, I didn't keep very good books and records. Now that doesn't mean that any case that you can't look behind accounts, books and records. There can be a convincing explanation that you can give as to why they don't show the truth and why you haven't had the company's property, or indeed why you were entitled to the company's property. But that's evidence that you have to bring. Once you are found in possession of the company's property, you have to give an account. And the analysis that's been used by the courts on numerous occasions, including the Odessa case and GHLM Trading and Maru, is that, well, that's because you are basically a trustee. You take on the fiduciary duties that are that a trustee would ordinarily owe to a beneficiary. And one of the consequences of that is that you have the obligation to account with what you're doing with company property in the same way the trustee owes that corresponding obligation when it comes to trust property. So it's a very satisfactory remedy for either companies or more usually liquidators and administrators to say, look, we know you've had company property. It's now up to you to provide the explanation as to how you got that into your possession, be it through dividend, salary, etc. And you can't hide behind bad bookkeeping as a way to get out of jail free, because in doing so, you impeach yourself and you impeach your own performance of those same directors' duties. So, I've spoken at my usual accelerated pace, and we have managed to finish on time. If you have no questions, you are all free to go. And thank you very much for coming.